The law of the sea is the invisible legal grid that divides our oceans, dictating exactly who controls what in our planet's most vital shared space. Welcome to this explainer where we are going to master the exact framework of global maritime jurisdiction and figure out why it actually matters. Let's get right into it. Here is our roadmap for this lesson. We'll start by mapping the maritime zones, then look at sovereignty near the shore, followed by enforcement and economic rights, and the continental shelf and high seas. After that, we'll nail down some crucial jurisdictional distinctions, and finally, look at the leading cases and recap everything we've learned.
So part 1, mapping the maritime zones and measuring seaward from the baseline.
To really understand this map, you have to start at what we call the baseline. This is the officially recognized outline of a country's coast, and it's the starting line for everything we are about to discuss. Now, looking at this overview table, notice the foundational rule here. As you scan from top to bottom, moving further away from that coastal baseline out into the ocean, the coastal state's power steadily decreases. We start with absolute, full sovereignty, transition to mere enforcement, then to very specific sovereign rights, and eventually, way out there, to no rights at all. Let's start right up against the coast. Part 2, sovereignty near the shore, internal waters and the territorial sea. Imagine a foreign commercial truck trying to just merge onto your country's domestic highway system. It absolutely cannot do that without going through border control and getting legal permission, right? Well, the exact same concept applies to the waters immediately against the coast, places like ports, harbors, bays, and rivers. These are formally defined as internal waters. Because they sit landward or inside the baseline, the coastal state enjoys full sovereignty here. The rule is strictly applied. These waters are legally identical to land territory. Foreign ships have absolutely no right of entry without permission unless they are in severe, immediate distress. Now, let's move slightly offshore. Picture a band of ocean extending outward from that baseline up to a maximum of 12 nautical miles. This is known as the territorial sea, and it's governed by Articles 2 through 32 of the UN Convention on the Law of the Sea. Within this 12-mile band, the coastal state still maintains full sovereignty, and that means a complete vertical slice, up into the airspace and down into the seabed and subsoil. But there's a really massive catch here. This is the one place in international law where a country's full sovereignty is legally conditioned by the need to let others pass through peacefully. We call this condition the right of innocent passage. Basically, foreign ships are allowed to travel through a state's territorial sea as long as their passage does not prejudice the peace, good order, or security of the coastal state. So how does this work in reality? Well, say a foreign military submarine needs to pass through a country's 12 nautical mile zone. Under the strict rules of innocent passage, that submarine cannot just travel silently underwater. It is legally required to physically surface and explicitly fly its national flag while passing through. This brilliantly illustrates the exact rule. Innocent passage severely limits coastal state power in order to ensure global navigation while still protecting the host country. Moving further out, we hit Part 3, enforcement and economic rights, specifically the contiguous zone and the EEZ. Just outside that 12-mile territorial sea lies another band, stretching from 12 to 24 nautical miles from the baseline. We call this the contiguous zone. Now, you really need to note, this is not a zone of sovereignty. Instead, it offers a very narrow band of mere enforcement jurisdiction. Imagine a coastal state spots a smuggler dropping anchor just outside its territorial waters. The state can act, but its powers are restricted entirely to preventing or punishing infringements of 4 very specific categories of law: customs, fiscal, immigration, or sanitary laws. That is it. Nothing more. Pushing even further out, up to 200 nautical miles from the baseline, we enter a massive area called the Exclusive Economic Zone, or EEZ. Legally speaking, this zone is sui generis. That's a Latin term meaning it's totally unique. It's in a class of its own. It's neither territorial sea, nor is it the high seas. In plain, everyday terms, the coastal state has the exclusive right to drill for the oil and catch the fish, but a foreign cargo ship can still freely sail right through the water. So the precise legal rule is that the coastal state has sovereign rights to explore and exploit resources, while all other states retain high seas freedoms, like navigation, overflight, and laying submarine cables. To ground all this in reality, let's look at India's maritime legislation. Under its 1976 Act, India legally codified this exact seaward progression we've been talking about. They formally claimed a 12 nautical mile territorial sea, a 24 nautical mile contiguous zone, and a 200 nautical mile EEZ. They also made official submissions for an extended continental shelf to a body called the Commission on the Limits of the Continental Shelf, or CLCS. This is a perfect textbook example of how international law is applied directly in a nation's domestic legislation. Okay, part 4. The continental shelf and high seas. We are heading way out into the deep ocean now. Let's look down at the seabed itself. This is the continental shelf. Physically, it's the natural underwater prolongation of a state's land territory. Legally, it extends to the outer edge of the continental margin, or at a minimum, out to 200 nautical miles. With that CLCS approval we just mentioned, it can even extend up to 350 nautical miles. The coastal state has sovereign rights over the seabed resources here, but here is the most crucial legal concept to learn. These rights exist ipso facto and ab initio. Those Latin phrases mean by the fact itself and from the beginning. Simply put, a state naturally and automatically owns the resources in its continental shelf. It never has to officially claim it or occupy it. It's just inherently theirs. Above that seabed, in the actual water column beyond the 200 nautical mile EEZ, we reach the high seas. In international law, these waters are considered res communis, meaning they belong to everyone and no one. Out here, no single country owns the water. It is totally free for all for navigation, overflight, and fishing. So you might be wondering, who actually enforces the law out there? Well, the strict rule is flag state jurisdiction. If you are on a ship in the high seas, you are governed exclusively by the laws of the country whose flag is currently flying on your mast. Finally, we reach the deepest, most remote ocean floor, the seabed that lies entirely beyond any country's national continental shelf claims. This is legally known simply as the area. Under the law of the sea, the area is declared the common heritage of mankind. This is a really profound global justice mechanism. It's administered by the International Seabed Authority, and the entire goal is to ensure that the resources of the deep ocean belong collectively to all of humanity, rather than just being scooped up by the coastal states with the deepest pockets. Part 5, Crucial Jurisdictional Distinctions. Let's make sure we've mastered this terminology. The most frequently confused distinction in this subject is between sovereignty and sovereign rights. Look at the left side of this table. Full sovereignty applies near the shore, in internal waters and the territorial sea. It means absolute territorial control over the water, the airspace, and the seabed. On the right side, we have sovereign rights, which only apply in the EEZ and the continental shelf. Sovereign rights are highly functional and strictly resource-specific. You own the fish and the oil, but you do not own the water itself. You must never confuse those two concepts. Similarly, we have to distinguish between mere jurisdiction and having no rights at all. In the contiguous zone, the coastal state has mere jurisdiction, a police power strictly limited to enforcing those 4 categories we talked about: customs, fiscal, immigration, and sanitary laws. Compare that to the high seas, where the coastal state has absolutely no rights over foreign vessels whatsoever, because they are governed entirely by flag state jurisdiction. All right, part 6, leading cases and our recap. Let's look at the legal architecture of ocean law. First up is the North Sea continental shelf cases decided by the International Court of Justice in 1969. Here are the facts. You had a dispute between Germany on one side and Denmark and the Netherlands on the other. Because their coasts are right next to each other, they needed to figure out how to draw invisible lines to divide up their shared underwater continental shelf. The core legal issue was whether a specific boundary drawing technique, called the equidistance method, was considered binding, customary international law that Germany was legally forced to follow. The court ruled that no, the equidistance method was not binding customary law. But why this case really matters is the vital holding they established regarding the seabed itself. They confirmed that continental shelf rights exist ipso facto and ab initio as a natural prolongation of land territory. This historic ruling permanently cemented the rule that a state's rights to its underwater shelf are automatic and inherent. They require absolutely zero occupation or official proclamation to exist. The second landmark case you need to know is the South China Sea arbitration of 2016, heard at the Permanent Court of Arbitration. In this case, the Philippines challenged China's massive historic claims to the ocean, which were visually represented on maps by a 9-dash line. The tribunal also had to evaluate Article 121, Paragraph 3 of the Convention. The specific issue there was whether tiny, unlivable maritime features, basically rocks in the ocean, could legally generate massive 200 nautical mile exclusive economic zones. The tribunal's holding was absolutely monumental. First, it completely rejected China's nine-dash line as being legally inconsistent with the law of the sea. Second, in interpreting Article 121, Paragraph 3, it laid down a very strict rule for maritime features. The tribunal held that rocks that cannot sustain human habitation or an economic life of their own generate only a 12 nautical mile territorial sea. They get no EEZ, and they get no continental shelf. This was huge because it drastically limited states from using tiny, barren rocks to claim vast economic monopolies over the ocean.
Let's recap the exact seaward progression we've learned today. Step 1, internal waters, acting exactly like land with full sovereignty. Step 2, the territorial sea, extending 12 nautical miles, featuring full sovereignty but heavily conditioned by the right of innocent passage. Step 3, the contiguous zone, granting narrow enforcement jurisdiction up to 24 nautical miles. Step 4, the EEZ and continental shelf, granting resource-specific sovereign rights, but without actually owning the water itself. And finally, Step 5, the high seas and the area, defined by flag state freedom and the common heritage of mankind. You now possess a precise, legal understanding of how our oceans are divided. But as technology advances and resources become increasingly scarce, from the absolute authority of those internal waters to the shared heritage of the deep ocean, how will these evolving zones dictate the future of global maritime security? Keep that question in mind as you continue your studies.